Mic check. 1, 2. Are we recording? Hi, I'm Michelle Bernstein, an award-winning chef, restaurateur, and mom. I have a lot on my plate, including my psoriatic arthritis symptoms. That's why I was prescribed Cosentyx. It helps me move better.
Cosentyx secukinumab is prescribed for people 2 years of age and older with active psoriatic arthritis. Don't use if you're allergic to Cosentyx. Before starting, get checked for tuberculosis. An increased risk of infections and lowered ability to fight them may occur, like tuberculosis or other serious bacterial, fungal, or viral infections. Some were fatal. Tell your doctor if you have an infection or symptoms like fevers, sweats, chills, muscle aches, or cough, had a vaccine or plan to, or if inflammatory bowel disease symptoms develop or worsen. Serious allergic reactions and severe eczema-like skin reactions may occur. Learn more at 1-844-COSENTYX or Cosentyx.com.
Ask your rheumatologist about Cosentyx.
This is the Roger Stone Show on 77 WABC.
A man who's gone through hell, but he's kept going, and he's smart, and he's strong, and people love him. Not everybody, but people love him and respect him. Roger Stone.
Now, here's Roger Stone.
Welcome. I'm Roger Stone, and this is The Roger Stone Show at 77 WABC Radio. We are indeed the crown jewel of AM radio. We are nothing less than the most influential, powerful AM radio station in the United States. And if you don't live in the greater New York, New Jersey, Connecticut area where I grew up, you can hear us worldwide by going to WABCRadio.com. We are live streaming in 163 countries worldwide. So there's never any excuse to miss any of the great programming here at 77 WABC. In fact, I urge you to go to the App Store on your phone right now and download the 77 WABC Radio app so you don't miss any of the great entertainment or talk programming that we have here at 77 WABC. There have been a number of significant legal developments in the ongoing tsunami of lawfare against President Donald Trump. And here to help us break that down is David Schoen, who is a criminal defense attorney, also an expert in appeals litigation. David very ably represented President Donald Trump in one of the impeachment trials on the floor of the U.S. Senate. He is a graduate of the Columbia University School of Law, where he got his master's degree. He is also a Juris Doctor at the Boston College Law School, where he graduated cum laude, and he did his undergrad at the same place that I tried to, George Washington University. David Schoen, welcome to the Roger Stone Show.
Thank you very much.
So we saw Special Counsel Jack Smith, whose appointment has been challenged by Judge Eileen Cannon, who ruled in the 11th Circuit, that's Florida, that his appointment was unconstitutional based on the fact that there is no law providing for his position, and that he was given these broad and sweeping prosecutorial powers without ever having been confirmed by the U.S. Senate. There's also a legitimate legal question about the funding of his investigation. But as I understand it, the ruling in one circuit does not bind the legal actions in another circuit, at least not until that question gets to the Supreme Court, which I guess we both expect it to do. Special Counsel Smith has said that he will appeal. I think he's filed his appeal with the 11th Circuit. Unclear what that panel will do, but this is a question clearly that will go to the U.S. Supreme Court. But then, in the wake of a disastrous debate and the Democrats switching out their candidate, in the wake of the horrific attempt on President Donald Trump's life in Butler, Pennsylvania, about which we still have more questions than answers, in the wake of Joe Biden's withdrawal from the race and the Democrat National Convention, in the wake of the historic endorsement of President Donald Trump by Robert F. Kennedy Jr. and former Democrat presidential candidate Tulsi Gabbard. Special counsel Jack Smith filed a superseding indictment in D.C. Against President Trump. David, what's going on here?
All part of the same campaign that Jerry Nadler, frankly and probably unwisely, spoke about. And that is that the Democratic Party doesn't feel they can trust the voters and they shouldn't rely on the voters. And therefore, they try all of these other measures to knock down President Trump and distract him from the election. So it's outrageous that Jack Smith did this. It was on the eve of a hearing scheduled in the D.C. case in which each side was supposed to propose a schedule to the judge to determine how to parse through the indictment, to determine what are official acts and what aren't. That's the instruction that she was given from the United States Supreme Court in the immunity case. So a number of things about this indictment. First of all, as you well know, there's this informal rule in the Justice Department called the 60-day rule. Some refer to the 90-day rule, but let's call it the 60-day rule, in which they're not supposed to take any action that could affect the election by bringing in, for example, a criminal case. So they're making excuses now by saying, well, it's not a new indictment. It's a case that's been around. It's just a superseding indictment. And now it's really up to the judge and so on. And they say we're not inside that 60-day window, but the election date is in November. That's complete nonsense now that we have early voting. The election's beginning in just a matter of days, really, with early voting, absentee voting, all of that. It's clearly done to affect the election. Shouldn't have been done. But he's still left with the same similar problems. That is, they're going to have to parse through this to determine what are the official acts. Now, one of the interesting things, the immunity decision from the Supreme Court was not only that a president can't be prosecuted for official acts, even within the outer parameters of official acts, but it also said that you can't use official act evidence to get an indictment or to put before a jury on other charges. And so Jack Smith is now saying, well, this new grand jury didn't hear the evidence earlier, which tells you that clearly the first indictment was tainted and could not have withstood scrutiny, because clearly he must have put forward official acts evidence before the grand jury. But here, it still deals with the communications with Vice President Pence and all that. And on that question, the Supreme Court spoke directly. They said, in their opinion, I'm quoting, whenever the president and vice president discuss their official responsibilities, they engage in official conduct, presiding over the January 6th certification proceeding at which members of Congress count the electoral votes is a constitutional and statutory duty of the vice president. Went on to say those discussions, communications would be presumptively immune from prosecution. So you're going to have to deal with all of that. You raised a very interesting point, and that is Judge Cannon's decision that Jack Smith's appointment was unconstitutional, both under the Appointments Clause of the Constitution and the Appropriations Clause. As you know, and we've discussed before, President Trump's lawyers never raised that issue in the D.C. case, unfortunately, in my view. In fact, there was some interest in it by the Court of Appeals, and an amicus brief was filed by a distinguished professor and by Ed Meese. And when asked about specifically to address that, President Trump's lawyer said, well, we never raised that issue in this case. Same thing happened in the Supreme Court, basically. So we'll see now. There's a new indictment. They have a new chance for new motions. They might raise it. They think they're making a strategic decision, I suppose, not to. There's a D.C. Circuit case that goes the other way, but without much analysis. So as you said, the 11th Circuit's not binding. The 11th Circuit hasn't decided yet. Judge Cannon's decision is brilliant, I think, very well thought out. And she's a distinguished judge, notwithstanding all of the criticism she gets in the media attacking her. But yeah, so they also, what's surprising to me and disappointing, in this new indictment, they kept in the obstruction charges. They have no place in this case. The Fisher case, decided by the Supreme Court in June of this year, said that this section of the criminal law, 1815-12 C2, only applies obstruction with respect to impairing documents, the ability to use documents records, or other objects like that. That's not what this case is about. This is a claim that in his speech, President Trump interfered with the election, and talking to Vice President Pence, he interfered, calls to Georgia, and so on. This isn't about documents. They wanted these counts in there, 2 counts under 1512, because they're 20-year counts. They shouldn't be in the case.
It was kind of obvious to me the fact that this 1520 charge grows out of the Enron case. Whose idea do you think this was?
Well, you raise a great point, because what we saw before this case started was a model prosecution memo, so-called, directed to Lisa Monaco and the Justice Department and others. And behind that was purportedly Andrew Weissman of the Enron case, Norm Eisen, Joyce Vance, that whole crowd, Danya Perry. They wrote a number of prosecution memos, some on the others, for each of these cases. And they also suggested, by the way, and I think this is telling, that President Trump be charged with insurrection under 18 U.S.C. 2383. You'll notice they never charged him under insurrection, and they never should have. And that's the key here. When they keep saying he tried to steal the government and wouldn't allow the peaceful transfer of power, that would have been insurrection. They have no basis for saying that or for charging it, except to try to win an election. If the voters are smart and they recognize what went on here, President Trump should go soaring up in the polls again because of this indictment. It's the same kind of weaponization, and it shouldn't have been done.
Just interestingly, yet again, in her convention speech, Kamala Harris said, and I quote, "Trump sent an armed mob to the U.S. Capitol." That's simply not true. Nobody arrested in the U.S. Capitol or on the grounds was armed. The only folks who were armed those days were Capitol Hill police officers and other federal agents, but the FBI director can't tell us how many undercover agents may have been there that day. These people just continue to recycle the same lies. I watched David Axelrod last night. Now, he's a very smart guy. I think he really is the guy who made Barack Obama president, recognized his political talent, recognized that the American people were sick of dynasties. They didn't want any more Bushes or Clintons. He really is a very smart guy. But once again, he repeats this claim that Donald Trump denigrated people who lost their lives in the service of their country as suckers and losers. There were 19 people present when that was allegedly said, and every single one of them denies that the president said it. The man who makes this claim, General John Kelly, was ignominiously fired by Donald Trump for incompetence and insubordination, and only after he's fired does he come up with this canard, for which he is the only witness, a biased witness, I would submit to you. So we're looking at a situation in which they keep recycling falsehood after falsehood after falsehood. We have coming up the sentencing in the New York court before Judge Juan Merchan, but there are developments in this case as well.
Yeah, first of all, that never should go forward. He denied another recusal motion. I believe his recusal, his disqualification from the case, is absolutely mandated under New York law. There's no question that his daughter's interests could be substantially affected by the proceedings there. She represents Ms. Harris and so on. And now it's even more important for the sentencing because, look, we hear these cheers about lock him up, lock him up. There's great pressure to put in some kind of punitive measure against President Trump. And this Judge Merchan would love it. He's a Trump hater from start to finish. He has no business sitting on this case, period. That's for starters. But now this new development is yesterday, the Trump team filed a petition in federal court to stop these proceedings, and the case ought to be heard in federal court. This was tried once before in this case, and it's assigned to the same judge, Judge Alvin Hellerstein, who rejected it. There's a federal statute, 28 U.S.C. 1442 A1, that allows for the removal of a criminal case against a federal government official acting under or anything relating to an act under the color of that office. And that's the argument they're making, that what he did, part at least of this case, relates to what happened when he was in office. And there clearly was evidence put on and evidence presented to the grand jury about things that he purportedly did while in office. It's also the subject of a hearing to come up, or a decision at least, before Judge Merchant based on the immunity decision, what, if any, official acts were either presented to the jury there or to the grand jury. And that case stands alone because it's the only one that's gone to trial. And so any official act evidence presented to the jury would have tainted any conviction in the case. So they have to see what happens. It's very difficult to get a win with this Judge Merchant, but hopefully down the road, some court is going to, certainly a federal court will, when it gets to that point, but hopefully a New York appellate court will reverse the convictions in that case.
David, is it correct that the president cannot file an appeal until after he's sentenced?
Correct.
In the New York matter?
That's when the judgment is entered in the case.
Interesting. While we're still on New York, what is your feeling of the final disposition of the Engoron case? This is the valuation case, which was unlike anything I've ever seen. Trump was essentially declared guilty before he even had a trial, and the only purpose of the trial was to figure out how much he was going to have to pay in order to impoverish him. And then he was required to post an enormous bond just so that he could appeal the case. That doesn't seem very fair or democratic to me.
Yeah, I believe absolutely that case will be reversed for a number of reasons. Remember, they're dealing there with an executive law that calls it fraud, but it's the only situation for a fraud in which there doesn't have to be any material misrepresentation that was relied on to the detriment of any person. Here, the bank said they were great loans, we made money off of it and all that. But I'll tell you to my view, is one of the biggest issues in this case, and I don't think the lawyers have raised it the way I would have raised it, at least. In fact, I know they haven't, and that is the denial of a right to a jury trial. The statute doesn't permit it. There's a case out of the same court in New York that said you don't get a jury trial under this executive law because it's really about equitable relief, about stopping a business practice, something like that. And damages are only incidental to the law. That's what the case says. Well, in this case, damages aren't incidental. This is a massive, massive damages judgment that couldn't be incidental to any kind of case. And interestingly, when this same law was used in a case in federal court, the federal judge said there is a federal right to a jury trial under this law. Now, the Seventh Amendment is what really gives the right to a jury trial in federal court, and that's not applied to the states. But the same reasoning that he used should have been applied here. And I think one of the primary issues here is that he was denied his right to a jury trial under the New York Constitution. And if not, then the law is unconstitutional if it doesn't permit a jury trial. There's a question here about whether his lawyers missed the date for asking for a jury trial, but I don't think there's a strong waiver claim here because it would have been futile to raise it since a court had already said you don't get a jury trial.
Fascinating. Let's go back for 1 second to the federal question because I think it makes a key point. What is the very fastest that Mr. Smith's D.C.-based charges could come to trial? So presumably he's now made a new motion. He's filed new charges. Those were he to be were that to go to the trial court, Trump would clearly appeal any decision there to the circuit. I'm familiar with the D.C. circuit. You can't really expect a fair shake there, but then would ultimately, presumably, go to the Supreme Court. Would this not take at least a year or longer?
It should. I've had a case. I actually recently won a case in front of Judge Chutkan, the judge who has the case. She's taken a very strong view against President Trump in this case. I had a great experience with her, but in this case, she's taken a tough view, and they seem to want to push it along. There's no way this case should go to trial anytime in the near future. They still have to resolve all of these fundamentally important questions, like any official act evidence that went to the grand jury and any official act evidence apparent from the indictment itself. That's one. Then the obstruction charge and stuff. They're going to have to litigate how under Fisher this can still be upheld. You can be sure they're going to try, the government, Smith is going to try to say, well, there were some documents involved here or there, like they do with the wire fraud statute sometimes to bring it within that. But it's not fair in this case. That wouldn't be accurate. That's not what this case ever was about, documents, records, or other objects like that. And that's what the Fisher court said. And then if the lawyers in this case decide to raise the constitutionality of Jack Smith's appointment, that also is going to have to be litigated in the case.
Folks, if you're just tuning in, this is the Roger Stone Show. I'm Roger Stone. We're talking to David Schoen, criminal defense lawyer who has ably represented President Donald Trump in one of his 2 impeachment trials on the floor of the U.S. Senate, and we'll be right back.
This episode is brought to you by Progressive Insurance. Do you ever find yourself playing the budgeting game? Well, with the Name Your Price tool from Progressive, you can find options that fit your budget and potentially lower your bills. Try it at Progressive.com. Progressive Casualty Insurance Company and Affiliates. Price and coverage match limited by state law. Not available in all states.
It's the Roger Stone Show on 77 WABC.
And folks, we're back. We're talking to criminal defense attorney par excellence, David Schoen. I do want to remind you, though, to please go to the App Store right now and download the 77 WABC radio app. Because let me tell you, you don't want to miss Sid Rosenberg in the morning. You don't want to miss Larry Kudlow on Saturdays. You don't want to miss Frank Morano on the other side of midnight if you're a night owl. You certainly don't want to miss John Katsimatidis and Rita Cosby with the Katz and Cosby Show, because it's the best roundup. At the end of each day, you can find out what happened that day and what's going to happen tomorrow. And of course, Sunday mornings, they really set the table for the entire day of news coverage. I don't want to leave out my friend Dominic Carter. There's so much talent. There's so much entertainment. There's so much great talk at 77 WABC Radio. You don't want to miss any of it. So by downloading the app, if because of work or family obligations you can't listen to your favorite shows, you'll be able to go back and hear all of it right there on the 77 WABC Radio app. We return now to David Schoen, a criminal defense lawyer who has distinguished himself in his representation of President Donald Trump in one of his impeachment trials. David, I wanted to get you on this a couple of weeks ago. President Joe Biden has put forward a package of what he calls Supreme Court reforms. Now, I think it's reasonable to expect that Kamala Harris, were she to be elected, would proceed, because neither one of them came up with those reforms. I don't think either one of them are currently running our current government. That, I think, is being done by a bunch of unelected bureaucrats at the highest level of government, with a healthy assist from President Barack Hussein Obama. But tell us your view on this Supreme Court reform package, because I haven't seen anything this draconian since Franklin Roosevelt, after the U.S. Supreme Court rejected several aspects of his New Deal, attempted to pack the court with a number of new justices, something that was rejected by the body politic in the United States.
Yeah. First of all, I don't buy into their terminology. I don't consider this a reform in any sense, to the extent that word has positive connotations, just like I refuse to use the term progressive to refer to the hate squad. They're regressive. And in this case, this would be a destruction, in my view, of the institution of the Supreme Court. The framers of the Constitution knew what they were doing when they gave lifetime appointments to Supreme Court justices. It's provided for in Article 3, only based on bad behavior. They've been removed from office. They can be impeached if there's a significant problem, impeachment worthy. But otherwise, the main reason they did it was to be free from the politics of the day, from political pressures and so on. Giving a lifetime appointment, and I think it has worked, allows people to grow in office and to be more discerning in their opinions and so on. I think that has worked. So, one of the things he's trying to do, claims to want to do, and Harris would do if she were president, be to try to get a constitutional amendment passed to change the lifetime appointment to some series of years, 18 years, 20 years, something like that. And I think it's really, really a terrible idea. The other would be to change the number of the justices. Now, the number of the justices has changed many times over the years. from 6 to 9 to 10 to anywhere in between, and an effort to make even more in the Roosevelt administration. This has always been the product of, again, the politics of the day, court packing efforts to try to get one political party more highly represented in the Supreme Court and so on. Again, to me, it's a sacred institution that we don't mess with that way. 9 has worked fine for 150 years. So I just don't like the idea of it. It's just more of this change for change's sake, and it's wrongheaded, especially in a country as polarized as we are right now. We're looking for some sense of normalcy and some sense of portraying strength around the world, not upheaving institutions like the Supreme Court because we don't like any given decision on abortion or some other hot button issue of the day. And we should be careful not to misconstrue what these decisions say, which has happened terribly with the immunity case. The immunity case is nothing more than the same thing we did in the civil context in Nixon versus Fitzgerald, which has stood up quite well through the times. And the reasons apply, and the court said in this case, they apply even more strongly to criminal prosecution when we're talking about official acts. Part of the problem is, President Trump's lawyer, not speaking for President Trump, speaking for himself in response to a question, was asked, that question, what if a president orders SEAL Team 6 to commit a hit on a presidential opponent? Could he be prosecuted? And the guy said no, he'd have to be impeached first. That's just dead wrong. It has no place in the public dialogue. It's not an official act under any circumstance, period. So we have to be careful of what we say, but we also have to be careful. The media is not careful in construing these decisions. You raised the point earlier about a claim Harris made that President Trump sent armed mobs in. Not only if people weren't armed, he didn't send them in. And he also said he wanted their voices to be heard peacefully. They always cut over that part of the speech and condemn him because they want to condemn him and find something to condemn him for. They're afraid of him because he doesn't put up with a lot of the nonsense. He does believe in this draining the swamp business as he did. They say, well, foreign governments, don't want him in. Yes, because he made NATO pay up. The things that he accomplished, he stuck with the promises he made. You know how many presidential candidates promised to move the embassy in Israel to Jerusalem, the capital that Israel says is their capital? Each one of them, year after year. We have a federal statute that requires them. Each one claimed national security, so they didn't move it. President Trump promised to move it. He moved it. He gave us the Abraham Accords. Nobody said could happen. These are enemies. We'll never speak to each other. He made it happen. So they're afraid of that kind of thing. The Democratic Party very much wants to hold on to power. And I say this not as a Republican. I represented the Democratic Party twice. I represented a socialist candidate for president in 2020. It's not a political issue. It's an issue that cuts at the very framework of our constitutional system and our electoral system we're seeing now. So, just got to play it straight at the polls. Let the American voters decide. One last thing I want to say on that point is, we saw this with Bobby Kennedy, the candidate. The Democratic Party, to an unprecedented degree, this election cycle, went into state after state, challenging Kennedy's candidacy, but the candidacy of third-party candidates all across the country, to an unbelievable degree in this case, really denying people the voice of their own candidate and their own policy position on the ballot. And it's outrageous what they did.
All right. I'm afraid we have to leave it there. When we come back, I'm going to talk about the incredible political development of Robert Kennedy's full-throated endorsement of Donald Trump. Let me thank our guest, David Schoen, a criminal defense attorney, often appears here on the Roger Stone Show. David, thank you so much for making time for us on this Labor Day weekend.
Thank you very much. Great honor.